This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. This case is about respecting the dignity of homeless individuals and the City of Grants Pass' ability to protect the safety and welfare of its citizens. Unsheltered homelessness is an ever-growing crisis nationwide, and the overwhelming majority of homeless individuals are not living that way by choice. According to the United States Department of Housing and Urban Development, HUD, there were an estimated 533,000 homeless individuals in the U.S. in 2018, more than a third of whom were unsheltered homeless, meaning individuals whose primary nighttime location was a public or private place not designed for or ordinarily used as a regular sleeping accommodation for human beings, including a car or a park or a camping ground. HUD's figures are obtained using what is known as a point-in-time, or PIT count, which, as its name suggests, is arrived at by counting the number of people in a city or county who are homeless on a particular night. HUD requires local homelessness assistance and prevention networks to conduct a PIT count each year as a condition of federal funding. A 2001 administrative study found that the true size of a homeless population may be anywhere between 2.5 to 10 times larger than what can be estimated by a PIT count. As the Ninth Circuit recognized in the Martin versus City of Boise case, there are many reasons for this undercount. Quote, "It is widely recognized that a one-night point-in-time count will undercount the homeless population, as many homeless individuals may have access to temporary housing on a given night, and as weather conditions may affect the number of available volunteers and the number of homeless people staying at shelters or accessing services on the night of the count." To combat the homeless crisis, many local governments have created ordinances, such as the ones challenged by plaintiffs in this case, that ban camping or similar activities in all or parts of a city. These ordinances are often referred to as quality of life laws. Enforcing quality of life laws is an expensive endeavor nationwide. For example, the City of Los Angeles spends $50 million annually on policing criminal and civil quality of life laws. By contrast, the City of Los Angeles spends only $13 million on providing housing and services to the country's largest homeless population. Likewise, a Seattle University study found that the cost to the City of Seattle for enforcing just one of its 6 quality of life laws was $2.3 million over 5 years. The City of Grants Pass, Oregon, the city involved in this case, had a population of 23,000 people according to the 2000 census, and it is now estimated to have more than 38,000 people. The development of affordable housing in Grants Pass has not kept up with the population growth. City Manager Aaron Kubik confirmed in his deposition that Grants Pass has a vacancy rate of 1%, and that essentially means there's no vacancy. Kelly Wessels, the chief operating officer of the community action agency that serves Grants Pass, testified that Grants Pass stock of affordable housing has dwindled to almost zero. Landlords routinely require an applicant to have an income that is 3 times the monthly rent. Rental units that cost less than $1,000 a month are virtually unheard of in Grants Pass. A point-in-time count of homeless individuals was conducted by the United Community Action Network on January 30th, 2019 in Grants Pass. UCAN counted 602 homeless individuals. Another 1,045 individuals were counted as precariously housed, meaning that they were sleeping at the home of somebody else, or couch surfing. In March 2013, the Grants Pass City Council hosted a community roundtable, hereinafter referred to as the 2013 Roundtable Meeting, to identify solutions to the current vagrancy problems. Minutes from this meeting show that the City Council president stated, "The point is to make it uncomfortable enough for them in our city so they," referring to homeless individuals, "will want to move on down the road." At the end of the meeting, a list of actions to move forward on was created. These actions included 1. Ways to increase police presence downtown. 2. Create a exclusion zone and possibly have a blanket trespassing regulation. 3. Specific amount of misdemeanors leading to prosecution. 4. Not feeding in parks or other specific areas of the city. 5. Posting zero-tolerance signs stating certain ordinances will be strictly enforced. 6. Look into the possibility of creating a do not serve or most unwanted list. 7. Pass out the trespassing letters and get word out to have them signed. And 8. Provide assistance in constructing safe areas at agencies to protect volunteers from aggressive behavior. City Manager Aaron Kubik confirmed that the action items from the 2013 Roundtable meeting were copied into the city's strategic plans in the form of an objective to address the vagrancy issue, starting with the 2013-14 Grants Pass Strategic Plan and up until the current 2019 Grants Pass Strategic Plan. The city manager also confirmed that one of the action items related to this objective was the targeted enforcement of illegal camping. There are no homeless shelters in Grants Pass that qualify as shelters under the criteria provided by HUD. The housing option cited by the city that most resembles a shelter is the Gospel Rescue Mission, GRM, which operates transitional housing programs in Grants Pass. GRM Director of Residential Services, Brian Buteller, testified that GRM offers 30-day transitional housing in 2 facilities, one facility for women and children with a capacity for 60 people, and the other for men with 78 spaces. There is no program for men with children or unaccompanied minors. Homeless individuals in these programs are required to work 6-hour days 6 days a week in exchange for a bunk for 30 days. During this 30-day period, people are not permitted to look for outside work. It is mandatory that GRM residents attend a traditional Christian chapel twice a day and go to a Christian church that follows the Nicene and Apostles' Creed every week. Before a person is considered for admission at GRM, they must agree to comply with a lengthy list of rules. For example, if you have serious or chronic medical or mental health issues that prevent you from participating in daily GRM life, you may not be able to stay at the GRM. You are to remain nicotine-free during your stay at GRM. All intimate relationships other than legal or biblical marriage, regardless of gender, either on or off mission property, are strictly forbidden. GRM has avoided seeking government funding so that it can maintain these restrictive rules. Class representatives allege that their situations are just 3 representations of modern homelessness in the U.S. Class Representative Deborah Blake lost her job and housing approximately 10 years ago and has been involuntarily homeless in Grants Pass ever since. At the time of class certification, Ms. Blake was living in temporary transitional housing, but her 90-day stay expired and she has returned to sleeping outside. As recently as September 11, 2019, Ms. Blake was cited for illegal camping and prohibited conduct in Riverside Park in Grants Pass because she was laying in the park in a sleeping bag at 7:30 a.m. Ms. Blake was convicted and fined $590. Later that same morning, the same officer wrote Ms. Blake a citation for criminal trespass on city property with an associated fine of $295. Ms. Blake was also issued a park exclusion on September 11, 2019. Ms. Blake filed an appeal and the exclusion was lifted without explanation after she had already been excluded from all of Grants Pass parks for 2 weeks. Currently, Ms. Blake owes the city over $5,000 in unpaid fines related to enforcement of the ordinances at issue while living outside in Grants Pass. Class Representative John Logan has been intermittently homeless in Grants Pass for the last 10 years. Mr. Logan currently sleeps in his truck at a rest stop north of Grants Pass because he fears being awakened and ticketed if he sleeps in his truck within the city. Mr. Logan is a licensed home care provider and his clients have allowed him to sleep on a mattress in a room they use for storage approximately 4 to 5 nights per week. However, that job ended in October or November of 2019. Class Representative Gloria Johnson has been living out of her van since at least before this litigation began. Ms. Johnson has parked her van to sleep outside of town on both BLM land and county roads. Bureau of Land Management, not Black Lives Matter. She claims that she has been asked to move along several times. While the exact circumstances and stories may vary, the 3 class representatives all share the need to conduct the life-sustaining activities of resting, sleeping, and seeking shelter from the elements while living in Grants Pass without a permanent home. Plaintiffs allege that the city of Grants Pass, through a combination of ordinances, customs, and policies, has unconstitutionally punished them for conducting life-sustaining activities and criminalized their existence as homeless individuals. plaintiffs seek an order from this court declaring that the city's enforcement of Grants Pass municipal codes, the anti-sleeping ordinance, the anti-camping ordinance, the park exclusion ordinance, and the trespass laws, are unconstitutional as applied to plaintiffs' class. Plaintiffs are also seeking an injunction prohibiting the city from enforcing those ordinances and related criminal trespass laws against the plaintiffs' class unless and until members of the class have the opportunity to obtain shelter within the city. The ordinances are listed below. Camping in a campsite, place where bedding, sleeping bag, or material is used for bedding purposes. Sleeping on sidewalks is prohibited. Sleeping in the entrances to garages and such is prohibited. Camping is prohibited on any sidewalk, street, alley, lane, public right-of-way. It is unlawful to camp in a park. Overnight parking of vehicles is unlawful. You may be excluded from city park properties if you are issued 2 or more citations within a 1-year period. That's pretty mean. Or issued citations for state law violations. You can appeal, but it looks like your appeal has to be filed within 2 business days, which is pretty short. The 2 camping ordinances carry a mandatory fine of $295. The fine for illegal sleeping is $75. When unpaid, the fines increase to $537.60 and $160 respectively due to collection fees. Plaintiffs were provided 615 citations and 541 incident reports issued pursuant to 3 of these ordinances, the Anti-Sleeping, Anti-Camping, and Anti-Camping in Parks Ordinance. Of the 615 tickets, 313 were for illegal sleeping, 129 for illegal camping in the parks, and 182 for just illegal camping. Some citations were for more than one offense. The number of citations rose from 24 tickets in 2012 to 228 tickets in 2014, a significant increase following the 2013 roundtable meeting. So now the court's going to go over a little bit of Martin v. Boise, which is a case from I think it was the Ninth Circuit, regarding the Eighth Amendment, cruel and unusual punishment. The United States Constitution prohibits punishing people for engaging in unavoidable human acts, such as sleeping or resting outside when they have no access to shelter. In the Martin v. Boise case, the Ninth Circuit held that so long as there is a greater number of homeless individuals in a city than the number of available beds in shelters, a city cannot punish homeless individuals for involuntarily sitting, lying, or sleeping in public. That is, as long as there are no emergency shelter beds available to homeless individuals, the government cannot criminalize indigent homeless people for sleeping outdoors on public property on the false premise that they had a choice in the matter. Martin is binding precedent on this court. In Martin, 6 plaintiffs who were or had recently become homeless residents of Boise, Idaho, challenged 2 city ordinances that punished homeless people for sleeping or camping in public spaces. The Boise camping ordinance prohibited and punished the use of any streets, sidewalks, parks, or public places as a camping place at any time. Camping was defined as the use of public property as a temporary or permanent place of dwelling, lodging, or residence. The Boise Disorderly Conduct Ordinance prohibited occupying, lodging, or sleeping in any building, structure, or public place, whether public or private, without the permission of the owner or person entitled to possession or in control thereof. In this case, Grants Pass 2 anti-camping ordinances prohibit occupying a campsite on any publicly owned property in the city of Grants Pass. Campsite is defined as any place where bedding, a sleeping bag, or other material used for bedding purposes is placed for the purpose of maintaining a temporary place to live. The camping ordinances apply to all public spaces in Grants Pass at all times, including parks. The camping ordinances also prohibit anyone from sleeping in their cars for 2 consecutive hours within any Grants Pass park parking lot between the hours of midnight and 6 a.m. The anti-sleeping ordinance prohibits sleeping on public sidewalks, streets, or alleyways at any time. Additionally, no person may sleep in any pedestrian or vehicular entrance to public or private property abutting a public sidewalk. These ordinances, in combination, prohibit individuals from sleeping in any public space in Grants Pass while using any type of item that falls into the category of bedding or is used as bedding. Grants Pass takes the position that Martin simply confirms that a case cannot criminalize the unavoidable act of sleeping outside when there are not enough shelter beds available. Grants Pass argues that the city amended its anti-camping ordinances to remove the word sleeping after Martin. On January 2, 2019, the city amended the code by removing the word sleeping so that the act of sleeping was to be distinguished from the prohibited conduct of camping under the city's Camping in the Parks ordinance. The city's intent for making this change was to make it clear that those without shelter could engage in the involuntary acts of sleeping or resting in the city's parks, but would still be prohibited from the voluntary conduct of maintaining a campsite in the parks as a place to live. The court appreciates the city's attempt to comply with Martin. However, Grants Pass ignores the basic life-sustaining need to keep warm and dry while sleeping in order to survive the elements. Under Grants Pass ordinances, if a homeless person sleeps on public property with so much as a flattened cardboard box to separate himself from the wet, cold ground, he risks being punished under the anti-camping ordinance. Grants Pass cannot credibly argue that its ordinances allow sleeping in public without punishment when, in reality, the only way for homeless people to legally sleep on public property within the city is if they lay on the ground, with only the clothing on their backs, and without their items near them. That cannot be what Martin had in mind. Maintaining a practice where the city allows a person to sleep on public property, but punishes him as a camper if he so much as uses a bundled-up item of clothing as a pillow, is cruel and unusual punishment. Therefore, this court finds that it is not enough under the Eighth Amendment to simply allow sleeping in public places. The Eighth Amendment also prohibits a city from punishing homeless people for taking necessary minimal measures to keep themselves warm and dry while sleeping when there is no alternative form of shelter available. As was the case in Martin, Grants Pass has far more homeless people than practically available shelter beds. In Martin, the Ninth Circuit's math reflected 867 homeless individuals in Ada County, Idaho, and an unknown number in Boise, while Boise had 354 emergency shelter beds and 92 overflow mats. On January 30, 2019, the point-in-time count in Grants Pass counted 1,673 unduplicated individuals, 602 of whom were homeless and the rest of whom were precariously housed, or doubled up. The mathematical ratio in the record as it currently stands is 602 homeless people, with another 1,071 on the verge of homelessness in Grants Pass and, on the other side of the ledger, 0 emergency shelter beds. The numbers here are clear, overwhelming, and decisive. The Gospel Rescue Mission is the only entity in Grants Pass that offers any sort of temporary program for some class members year-round. However, GRM cannot be included in the mathematical ratio of homeless people to shelter beds because GRM has lost its designation as a HUD-certified emergency shelter. GRM is also considerably less accessible than even the shelters in Martin because it does not offer temporary emergency shelter and has substantial religious requirements and other restrictive rules. GRM does not offer emergency shelter, only a 30-day residential program. This program offers extended stays and is more akin to a transitional housing program than a homeless shelter. Additionally, there are several strict rules for residents of GRM, including remaining nicotine-free while on and off the premises, and mandatory attendance of a Christian church and other church-related activities. Even without these rules, GRM's 138 beds would not be nearly enough to accommodate the at least 602 homeless individuals in Grants Pass. Grants Pass argues that plaintiffs have alternative, realistically available shelter outside the city on federal Bureau of Land Management land, Josephine County land, or state rest stops. This remarkable argument not only fails under Martin, but also sheds light on the city's attitude towards its homeless citizens. Essentially, Grants Pass argues that it should be permitted to continue to punish its homeless population because plaintiffs have the option to just leave the city. The city's suggestion that because it is geographically smaller than Boise or other cities, it should be allowed to drive its homeless population onto nearby federal, state, or Josephine County land is not supported by Martin. Additionally, the record does not support the suggestion that homeless people are welcome to live without interruption by law enforcement at these locations. BLM land is available for recreational camping, not as a space for emergency shelter. The campsites cost money. Living, establishing occupancy, or using this land for residential purposes is specifically prohibited, and there are limits on how long a person can stay. Homeless people who attempt to live on BLM land are subject to trespass prosecution under federal law, fined $330, and summoned to this court. Likewise, Josephine County does not welcome non-recreational camping in its parks. The county issued a letter from its parks director November 12, 2019, stating that county parks are not a good alternative for non-recreational campers, individuals or families who need a place to sleep due to not having a permanent residence. That's what it says. This letter urges homeless services providers not to pay for campsites for homeless individuals in county parks. Similarly, camping, setting up a tent, or remaining in a rest stop for more than 12 hours in a 24-hour period are also explicitly prohibited. Finally, the city lists 3 services offered within Grants Pass that similarly do not change the equation under Martin. In February 2020, the Umpqua Community Action Network, UCAN, opened a warming center that may hold up to 40 individuals on nights when the temperature is either below 30 degrees or below 32 degrees with snow. Those 2 degrees make a real big difference, I'm sure. For the record, it appears 131 different people have stayed at the warming center since it opened. As of the filing of plaintiff's reply brief, the center has been open 16 nights and reached capacity on every night except the first night it opened, when it had 32 occupants. While the opening of a warming shelter is positive for the city, this emergency warming facility is not a shelter for the purposes of the Martin analysis because the facility does not have beds and is not available consistently throughout the year. Even if the warming center did count as a shelter under HUD, the capacity of the warming center is not large enough to accommodate the amount of homeless people in Grants Pass. The city also referenced a sobering center where intoxicated individuals may be temporarily held, and a youth shelter. The sobering center is not a shelter. It allows for temporary placement for highly intoxicated individuals while they sober up, and for individuals who are creating a nuisance but do not warrant a trip to jail. Plaintiffs claim that the sobering center has no beds and consists of a chair with restraints and 12 locked rooms with toilets where people can sober up for several hours. Hearts with a Mission Youth Shelter runs an 18-bed facility where minors aged 10 to 17 may stay for up to 72 hours unless they have parental consent to stay longer. This shelter does not have enough beds to serve the number of homeless individuals in Grants Pass and is not practically available to class members in this class because it is reserved for minors. The record is undisputed that Grants Pass has far more homeless individuals than it has practically available shelter beds. This case cannot be distinguished from the holding in Martin. The alternative shelters suggested by the city do not change the equation set out in Martin. Because Grants Pass lacks adequate shelter for its homeless population, its practice of punishing people who have no access to shelter for the act of sleeping or resting outside while having a blanket or other bedding to stay warm and dry constitutes cruel and unusual punishment in violation of the Eighth Amendment. Grants Pass argues that the Eighth Amendment analysis does not apply to the ordinances at this case because they are designed as violations and therefore are not criminal matters. To support this assertion, Grants Pass quotes the Oregon Court of Appeals, which found a violation is not a crime. However, the label of a crime or violation is not dispositive where the Eighth Amendment is concerned. The focus for Eighth Amendment purposes is the punishment associated with the crime, violation, or civil penalty. Even though Grants Pass labels the ordinances as violations, offenders of these violations are still subject to punishment. As the United States Supreme Court has held, the purpose of the Eighth Amendment was to limit the government's power to punish. The Cruel and Unusual Punishments Clause is self-evidently concerned with punishment. The notion of punishment, as we commonly understand it, cuts across the division between the civil and the criminal law. Unlike the Fifth Amendment's self-incrimination clause, the Eighth Amendment's prohibition on punishing an involuntary act or condition applies to punishment beyond criminal cases. The Supreme Court has made this clear. Quote, "The United States further suggests that the Eighth Amendment cannot apply to a civil proceeding unless the proceeding is so punitive that it must be considered criminal. We disagree. Some provisions of the Bill of Rights are expressly limited to criminal cases. The Fifth Amendment's self-incrimination clause, for example, provides no person shall be compelled in any criminal case to be a witness against himself. The protections provided by the Sixth Amendment are explicitly confined to criminal prosecutions. The text of the Eighth Amendment includes no similar limitation, nor does the history of the Eighth Amendment require such a limitation. The Supreme Court further opined that provisions of civil forfeiture were punitive because a civil sanction that cannot fairly be said solely to serve a remedial purpose, but rather can only be explained as also serving either retributive or deterrent purposes, is punishment, as we have come to understand them. Ultimately, the Supreme Court held that civil forfeiture constitutes payments to a sovereign as punishment for some offense, and as such, is subject to the limitations of the Eighth Amendment excessive fines clause. Violations of the Boise ordinances analyzed in Martin were misdemeanors, so the Ninth Circuit at times used the word criminal in its analysis. However, a careful reading of Martin shows that this language was not a limitation on when the Eighth Amendment's prohibition on cruel and unusual punishment applies. The Ninth Circuit stated the broad question that it was addressing was, does the cruel and unusual punishments clause of the Eighth Amendment preclude the enforcement of a statute prohibiting sleeping outside against homeless individuals with no access to alternative shelter? The Ninth Circuit held that it does, quoting the Jones case, quote, "The Eighth Amendment prohibits the state from punishing an involuntary act or condition if it is the unavoidable consequence of one's status or being. It is the punishment of a person's unavoidable status that violates the Constitution, not whether that punishment is designated as civil or criminal. The main difference between Grants Pass punishment scheme and that of Boise's in Martin is that Grants Pass first issues fines for violations and then either issues a trespass order or excludes persons from all parks before a person is charged with a misdemeanor criminal trespass. This makes no difference for Eighth Amendment purposes because the result is identical. Involuntarily homeless people are punished for engaging in the unavoidable act of sleeping or resting in a public place when they have nowhere else to go. Moreover, even if Martin and the Eighth Amendment were limited to criminal punishments, which they are not, Grants Pass enforcement scheme involves criminal punishment. Violations for sleeping and camping are an element of future criminal trespass 2 arrests and initiate the criminal process in two common circumstances. First, after a person is trespassed from an area for camping and either does not leave or returns, or two, after an officer excludes a person from a park for prohibited camping. In either situation, if that person does not move along or returns to the location, they are subject to arrest and prosecution for criminal trespass 2. The criminal process is initiated with the original citation, and that citation is an element of the subsequent criminal trespass charge once the person is trespassed or excluded under threat of arrest for criminal trespassing. Therefore, Grants Pass enforcement scheme is subject to Eighth Amendment analysis. Under such analysis, the ordinances at issue and their enforcement, as applied to plaintiff class members, violate the cruel and unusual punishments clause of the Eighth Amendment. Grants Pass enforcement of the ordinances at issue also violates the excessive fines clause of the Eighth Amendment. The Supreme Court has found that the phrase, "nor excessive fines imposed," in the Eighth Amendment limits the government's power to extract payments, whether in cash or in kind, as punishment for some offense. There is a two-step inquiry in analyzing an excessive fines claim: if the fine is punitive, and if so, is it excessive? To determine when a fine is punitive, courts look to whether the fine is tied to punishment and prohibited conduct. It does not matter if the fine imposed is characterized as criminal or civil. The salient inquiry is whether the fine at least partially serves the traditional punitive functions of retribution and deterrence. In this case, the court finds that the fines imposed for violating the ordinances at issue are punitive. According to the record, the two camping ordinances carry a mandatory fine of $295. The fine for illegal sleeping is $75. When unpaid, the fines increase to $537.60 and $160 respectively because of additional collection fees. Officers have the discretion to issue warnings prior to issuing a citation, but once a citation is issued, officers have no discretion over the amount of the fine, which is auto-filled into all camping citations. Based on the record and minutes from the 2013 Roundtable meeting, these statutory fines serve no remedial purpose and were intended to deter homeless individuals from residing in Grants Pass. Moreover, the ordinances themselves described these fines as punishment, quote, "maximum fine except in cases where a different punishment is prescribed by any provision of this code." Because the fines are punitive, the inquiry turns on whether the fines are excessive. The Supreme Court has held that a fine violates the excessiveness standard if the amount of the fine is grossly disproportionate to the gravity of the offense. Here, the decisive consideration is that plaintiffs are being punished for engaging in unavoidable, biological, life-sustaining acts of sleeping and resting while they are also trying to stay warm and dry. Plaintiffs do not have enough money to obtain shelter, so they likely cannot pay these fines. When the fine remains unpaid, the additional collection fees are applied, and the fines still remain unpaid, subjecting plaintiffs to collection efforts, the threat of driver's license suspensions, and damaged credit that makes it even more difficult for them to find housing, exacerbating the homeless problem in Grants Pass. This is known as the poor tax, and it's like a vicious cycle. It's like a hydraulic at the bottom of a dam that you just get caught and you just keep churning and turning and turning, and you can never get out of it. As the Supreme Court recognized in the cruel and unusual punishment context, even 1 day in prison would be cruel and unusual punishment for the crime of having a common cold. So too here. Fining a homeless person in Grants Pass who must sleep outside beneath a blanket because they cannot find shelter, $295 or $537.60 after collection fees, is grossly disproportionate to the gravity of the offense. Any fine is excessive if it is imposed on the basis of status and not conduct. For plaintiffs, the conduct for which they face punishment is inseparable from their status as homeless individuals and therefore beyond what the city may constitutionally punish. The fines associated with violating the ordinances at issue, as applied to plaintiffs, are unconstitutionally excessive. Under Grants Pass enforcement scheme, police officers may issue a written exclusion order barring an individual from all city park properties for a period of 30 days if within a 1-year period the individual is issued 2 or more citations for violating city park property regulations or 1 or more citations for violating any state law. A park exclusion goes into effect immediately upon being issued and is not stayed while a person appeals. The appeal period is within 2 business days, and the method of appeal is by written objection to the city manager, at which point the objection will be placed on the city council's agenda. 16 years ago, this court found a substantially identical appeal process in Portland's park exclusion ordinance to violate procedural due process rights. The risk of erroneous deprivation is compounded by the law's deficient appeal procedures and lack of pre-deprivation hearing. An exclusion takes effect immediately upon issuance and is not stayed pending appeal. Thus, a person excluded from a park is subject to arrest for re-entry as soon as she receives the exclusion notice. An appeal may be filed within 5 days, but the individual continues to be excluded from the parks. Thus, even if the exclusion is ultimately found to be invalid, the individual has been kept from the public park for at least a significant portion of the 30 days. For the same reasons, Grants Pass Park Exclusion Ordinance is also unconstitutional and violates the procedural protections of the Due Process Clause. The court then agrees that plaintiffs did not present enough evidence to make out an equal protection claim. This is on summary judgment. They'll still have a chance to present their evidence in a trial if it goes that far. Same thing for a substantive due process claim. It's not that they don't have rights or something, or those rights weren't violated, it's that they didn't prove it for summary judgment. The court has a nice conclusion. The holding in this case does not say that Grants Pass must allow homeless camps to be set up at all times in public parks. Just like in Martin, this holding in no way dictates to a local government that it must provide sufficient shelter for the homeless, or allow anyone who wishes to sit, lie, or sleep on the street at any time or any place. Nor does this holding cover individuals who do have access to adequate temporary shelter, whether they have the means to pay for it or because it is realistically available to them for free, but who choose not to use it. The city may implement time and place restrictions for when homeless individuals may use their belongings to keep warm and dry, and when they must have their belongings packed up. The city may also implement an anti-camping ordinance that is more specific than the one in place now. For example, the city may ban the use of tents in public parks, without going so far as to ban people from using any bedding-type materials to keep warm and dry when they sleep. The city may also consider limiting the amount of bedding-type materials allowed per individual in public places. Moreover, this holding does not limit Grants Pass' ability to enforce laws that actually further public health and safety, such as laws restricting littering, public urination or defecation, obstruction of roadways, possession or distribution of illicit or illegal substances, harassment or violence. Grants Pass would retain a large toolbox for regulating public space without violating the Eighth Amendment. There is no doubt that homelessness is a serious public health concern. Homeless individuals have higher rates of chronic physical and mental health conditions, increased rates of mortality, and related diseases and co-occurring disorders. With the lack of access to the most basic of human needs, including running water, toilets, and trash disposal, infectious diseases like COVID-19 can spread quickly. Uprooting homeless individuals without providing them with basic sanitation and waste disposal needs does nothing more than shift a public health crisis from one location to another, potentially endangering the health of the public in both locations. This concern is particularly acute during the current COVID-19 pandemic, as the U.S. Centers for Disease Control and Prevention explained in its interim guidance for responding to coronavirus disease 2019 among people experiencing unsheltered homelessness. Unless individual housing units are available, do not clear encampments during community spread of COVID-19. The court encourages Grants Pass to work with local homeless services experts and mental health professionals to develop training programs that cover techniques and tools for interacting with homeless individuals and for de-escalating mental health crises. For example, the city of Eugene, Oregon has used the services from an organization called CAHOOTS, Crisis Assistance Helping Out on the Streets, to provide free, immediate stabilization in cases of urgent medical need or psychological crisis, assessment, informational referral, advocacy, and, in some cases, transportation to the next step of treatment to the people of Eugene, Oregon. As the Wall Street Journal noted, Gary Marshall, a 64-year-old who previously lived on the streets of Eugene, said the police approach was name, serial number, and up against the van. In contrast, when he was having one of his frequent panic attacks, CAHOOTS counselors would bring him inside and talk him down, he said. Such trainings have also proven to be effective in Miami-Dade County, Florida, specifically providing mental health de-escalation training to its police officers and dispatchers enabled the county to divert more than 10,000 people to services or safely stabilizing situations without arrest. The number of people in jail in turn fell by nearly 49%, which allowed the county to close an entire jail facility, thereby saving nearly $12 million a year. The city of Medford, Oregon, has also developed new strategies for addressing the homeless crisis in its community. Medford worked with Rogue Retreat, a nonprofit group, to open Hope Village in November 2017. Hope Village is the first tiny homes community in southern Oregon that provides short-term transitional shelter and case management for individuals and families to help move from homelessness into long-term housing. The idea of Hope Village was created in 2013 when Rogue Retreat, St. Vincent de Paul, and the Jackson County Homeless Task Force began researching and visiting other villages in Oregon to find creative ways to serve the homeless in Jackson County. Hope Village started with 14 units, each 8 by 10 feet, plus a communal kitchen, laundry, and shower. Hope Village began operating under a 1-year agreement with the city, and in less than a year, the Medford City Council approved doubling the size of the village and signed a new 2-year agreement with Rogue Retreat. Medford City officials didn't create the project, didn't build the units, and don't operate the village. However, city leaders supported the concept from the beginning, offering a city-owned property for the village. When neighboring businesses and other property owners objected to the location, the city of Medford continued to offer support and encouragement, culminating in a new location. Hope Village now sits on property owned by the city of Medford and another property leased by Rogue Retreat. Residents of Hope Village are required to attend case management meetings, counseling sessions, and work on permanent ways to stay off the streets. Rogue Retreat says the average stay at Hope Village is around 4 months, and the program has a 62% success rate. According to Rogue Retreat, this means 6 out of 10 people in the program successfully move away from homelessness. Oregon's cities are obligated to provide safe and livable communities for all residents. Laws that punish people because they are unhoused and have no other place to go undermine cities' ability to fulfill this obligation. Indeed, enforcement of such quality of life laws do nothing to cure the homeless crisis in this country. Arresting the homeless is almost never an adequate solution because, apart from the constitutional impediments, it is expensive, not rehabilitating, often a waste of limited public resources, and does nothing to serve those homeless individuals who suffer from mental illness or substance abuse addiction. Quality of life laws erode the little trust that remains between homeless individuals and law enforcement. This erosion of trust not only increases the risk of confrontations between law enforcement and homeless individuals, but it also makes it less likely that homeless individuals will cooperate with law enforcement. Moreover, quality of life laws, even civil citations, contribute to a cycle of incarceration and recidivism. Indeed, civil citations requiring appearance in court can lead to warrants for failure to appear when homeless people who lack a physical address or phone number do not receive notice of relevant hearings and wind up incarcerated as a result. Moreover, unpaid civil citations can impact a person's credit history and be a direct bar to housing access in competitive rental markets where credit history is a factor in tenant selection. In this way, civil penalties can prevent homeless people from accessing the very housing that they need to move from outdoor public spaces to indoor private ones. There are many options available to Grants Pass to prevent the erection of encampments that cause public health and safety concerns without violating the Eighth Amendment. The court reminds governing bodies of the importance of empathy and thinking outside the box. We must try harder to protect our most vulnerable citizens. Let us not forget that homeless individuals are citizens just as much as those fortunate enough to have a secure living space. And that opinion was issued by Mark Clark, United States Magistrate Judge, on the 22nd day of July 2020, so just a few weeks ago. And I have it, I believe with the articles I've read said that the city of Grants Pass plans to appeal. So that's a magistrate judge's decision. The magistrate then goes to the district court. The district court will rule on that recommendation. The case can then be further appealed to the Ninth Circuit. But of course, the Martin case was Ninth Circuit, so unless this is somehow way outside of that ruling, I don't see how any appeal is going to survive. But that's really remarkable. That says to me that the homeless have rights. The very basic summary of this is that homeless people who are found to be in violation of these quality of life laws, which are obviously made to move the homeless along as opposed to rehabilitate or remedy the situation, that these cannot be applied unless there is a reasonable alternative. So if there is shelter for them to go to, then they should be taken to the shelter and not punished for sleeping in the park, unless they then continue to refuse to try to go to the alternative shelter. And this also means there has to be accommodation for people's substance abuse addiction or mental health problems. Not that they have to give them treatment necessarily, but they can't be punishing them for being homeless because of medical issues, including substance abuse addiction, which is a disease. So this is really remarkable. This should lead to basically a complete rethinking of a lot of the more difficult policies of these quality of life or anti-homeless laws. We also found something very interesting about the city of Grants Pass. Did you know they have a motto? Did you know the city of Grants Pass, Oregon's motto is "Live Rogue"? It's the climate. Are you kidding me? The city that doesn't want homeless people has a motto, "Live Rogue." Okay, like maybe they mean live differently or something, but come on, that's basically saying that homeless is like one way to live. Like, go ahead, live rogue. So very, very interesting coincidence or a bit of irony there. Anyway, I can't tell you what the exact consequences of that are going to be. This ruling only applies to Grants Pass, but the ruling should be used persuasively in other cases. And so I expect that within the Ninth Circuit at least, and probably have some effect nationwide, cities are going to have to rethink their quality of life laws so that they at least have an alternative, a reasonable alternative for the people who are homeless to seek shelter, to rest and sleep. And if they don't provide some kind of reasonable alternative, then these laws probably don't hold up. The problem there is many cities will continue to enforce their laws even if they're unconstitutional because homeless people aren't really in the greatest position to defend themselves in court. So it's only with the help of legal aid organizations, with volunteers, with lawyers, the ACLU, etc. You saw some of the names of the organizations here with Oregon. It's only with their help that this is even possible. So only with the empathy and caring of other humans. If it was left to the government, they would have just kicked the homeless out and make them somebody else's problem. And everybody kicks them out and makes them somebody else's problem, except for a few sanctuary cities. And that what is that? That can't be a valid policy in a country that prohibits cruel and unusual punishment, is what the judge was saying here. So let me know what you think in the comments below. I realize homelessness is a complex situation. Every time I have tried to defend policies to help rehabilitate the homeless, there's always a rather large number of people who basically say, at least I don't want it near my home. Don't build that shelter across the street from me. I just want it somewhere else. Well, everybody wants problems somewhere else and not at home. Well, I think if we had a little empathy and worked on the problem, we could maybe eliminate 62% of the problems, like the UCAN or Cahoots was saying that they did. So let me know what you think in the comments below, and if you are going to make the arguments that you don't want homeless people near you, fine, but try to make a substantive argument, like what is it specifically, and can't that be addressed somehow? Maybe if you don't want the shelter across the street from your house, well, will you then help support finding a place for a shelter that is more suitable, while still being in the local region, local enough that homeless people can be brought there when they need to sleep and rest, or come there on their own. So let me know what you think in the comments. So that's our show, everyone. Thanks for joining me. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education program here on YouTube, on Floatplane, and on Twitch. We are community supported, meaning we need your support on a monthly basis to keep our efforts going. Thank you to the following August 2020 supporters at the $50 level: Nicely Done Defense, Wes Delj, Citizen of the Sovereign, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Jan Negrey, Benjamin Hitov, Steven, Blackleaf, HotGrillsInYourArea, Longreach Jones, Definitely Not Prenda Law, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Jay Dixon, HotGrillsInYourArea, Ameknight, engi, Brandyn, Abel, Torpedan, and Creative Corruptions. The $5 plus supporters are all in the description and on my LED panel next to me. I'll see you guys in the videos that drop. I love you all. Have a good one. Bye.
Voilà, que c'est là, finalement. Qui est-ce